Okay, as people are settling back in, we had said that we weren't going to do lengthy introductions of people, and the introductions are in the program, but I do actually want to say a couple of things about our two distinguished panelists here, partly because there are people who are only going to see this through the online production, and they don't have the programs in front of them, but also because I want you to fully appreciate the range of experience that both of the people on the panel bring to bear. So first of all, Lisa Monaco, who's sitting to my left, has extensive experience in both the Justice Department and the White House. So she was the President's Homeland Security and Counterterrorism Advisor from 2013 to 2017. It notes here that she was personally responsible for advising the President on all aspects of Homeland Security, cybersecurity, and strategy. I think that doesn't say she was personally responsible for the actual policies adopted. But before that, she also spent 15 years in the Department of Justice, where, among other things, she served as Chief of Staff to the Director of the FBI, who at that time was Robert Mueller. So extensive experience both in the Justice Department and the White House. Mary DeRosa also has a tremendous range of experience because she worked in the legislative branch for many years, where she was the Chief Counsel for National Security for the Senate Judiciary Committee, and then moved over into the White House, where she was Deputy Assistant and Deputy Counsel to the President and the National Security Council Legal Advisor in the Obama administration. So we couldn't have two people who have richer sets of experiences with respect to national security, which is what this panel is going to be devoted to. And as I was thinking about this panel, I was struck by the fact that for most of the time since 9/11, there has been a standard set of legal issues about presidential power and the law of national security that we have been debating. Things like use of military commissions, whether detention policies for various categories of people are legal and permissible, AUMF or use of force kinds of issues, questions about interrogation practices, surveillance practices, and many of those issues still resonate, and there are still remains of those issues that are being debated. But the debate has moved, I think, a fair amount beyond that set of issues, and there are a range of newer issues that have come to the surface and are not just the continuation of the debates we've been having since 9/11. So one of those that we wanted to start with, I wanted to start with, involves the most significant national security issue facing the United States today and facing the world today, and that is obviously North Korea and the threats posed by North Korea. And so I thought I would begin by asking our panelists, given their experience, just to describe for the audience what the typical sort of internal processes of discussion, decision-making, advice-giving would look like with respect to this kind of an issue, at least based on their experiences in the White House, who would be involved, what kinds of discussions would take place, how would options be presented to the president. And I thought if you could just begin by giving us some feel for all of that, that might be a good starting point, and then we can ask a variety of more specific questions about the North Korea situation today. So Lisa, maybe if you can start.
Sure. Is this on? Okay. Why don't I start? I'm sure Mary will have lots to say about the lawyers group process that would inform the process that I'll talk about. So what I would say is in the Obama administration, in the process that I am familiar with, the hallmarks of the process that would have fed into decisions about North Korea, or frankly any other issue of such consequence, would be a few things. One would be an actual process, okay? There would be a disciplined process around the development of policy discussions and options or recommendations to the president. And those would be marked by a few characteristics. One would be inclusion of subject matter experts and deep regional policy, technical, legal expertise to inform the discussion. It would begin with the National Security Council staff, which is, of course, drawn from representatives of the national security and foreign policy agencies around the government, to kind of work up rigorous policy discussion papers and hopefully a set of options for the deputies committee to discuss and then inform going up the chain to the principals and ultimately to the NSC, chaired by the president. And so the things that we were very focused on in running that type of process, whether it was a counterterrorism issue, whether it was North Korea, would be inclusivity of the right people at the table, quite literally sitting at the Situation Room table, to make sure that you had the subject matter experts, multitude of voices, multitude of perspectives, quite frankly, from operators in the intelligence and military realm, to the foreign policy folks, to the regional experts and the like, to literally be coming together and hashing out potential options informed by a rigorous review of what the policy and strategy have been to date, and whether we ought to be rethinking things as we go along. So inclusivity, process, and rigor, I think, marked discussions, in my experience, around North Korea, as well as a whole host of other emergent issues.
I agree with all that, and I guess what I would add is how the law, my experience was as legal advisor at the NSC. I actually was also in the legal office at the NSC in the Clinton administration, so I have perspectives of different administrations, and the process is fairly similar. I think there were some changes to this process during the Bush administration, and that is that there's a group of lawyers called the Lawyers Group, and it is convened by the National Security Council legal advisor, but it includes all the senior national security lawyers in the administration, and the NSC lawyers are very actively in all of the meetings that Lisa just talked about, and which there are many of. And
No
then,
dearth of meetings.
and then, you know, from that, identify what legal issues have arisen, what legal issues might arise, get the lawyers together, and again, inclusion is very important. Try to get as many different perspectives and develop, hopefully in advance, not always possible, develop legal guidance for the policymakers.
If I might, Rick, just kind of give folks a little bit more of a concrete example. So, for instance, Kim Jong-un does a missile test, right? We had that experience multiple times when I was in the White House, and to the extent it happens kind of overnight, maybe you get some intelligence in advance that we think that they're moving that direction. You begin to get the wheels of this process that we're talking about moving in advance if you have any intelligence indications that this might be afoot. But certainly afterwards, and as you're getting intelligence in literally overnight about what we can discern of the nature of the test, whether it's a nuclear test or missile test, et cetera, what's our assessment of, does this mark in advance? What is the assessment of the intelligence community as to the kind of plans and intentions behind it, et cetera? And the Deputy National Security Advisor in the end of the Obama administration, Avril Haines, would pull together the deputies to come together and have a discussion about what should be our response. And there, the inclusivity piece is very important. So, for instance, in the Obama administration, the UN, the ambassador to the UN was a member a standing member of the NSC and the Principals Committee. So her, in the case of Samantha Power, her deputy was a member of the Deputies Committee. And so that person would be at the table and feeding into the question of, well, should one of our responses be to mount some action in the National Security Council in trying to advance a response there? We would have the Treasury Secretary and his deputy present in these discussions to say, should we be, one of our response options be a development of another round of sanctions? What State Department can you indicate to us will be the appetite amongst our allies and partners to support that type of a sanctions regime? And intelligence community, what can we say publicly about what we know about this test? How can we mount a kind of a set of responses that would serve to isolate the North Korean regime and what they have done? How can we make a case publicly about what this is and what it isn't, so as to kind of take away from the North Korean regime some of its kind of bellicose, kind of intent behind a particular action? So the point being that all of those tools, the sanctions, intelligence response, potential military responses, whether it's in kind of B-2 flights across the peninsula, et cetera, all of those are going to be surfaced because you have those voices at the table and chewed on and discussed and surfaced to the principals and, if necessary, to the president.
Now, this may be asking you something you have to speculate about or don't want to speculate about, but what's your sense of how the NSC is operating now, to the extent you have a sense? You talk to people in Washington, you are more informed than just those of us reading the paper. Do you think the NSC process, do you have any sense, is it working similarly? Is it working in dramatically different ways right now, particularly with respect to something like North Korea, though you may not know anything that specific? But what's your sense of the role of the NSC today in the Trump administration?
You go ahead.
I'll try. I mean, look, I think we have a few data points. One data point is the development and announcement and rollout of the travel ban 1.0 in the first week of the administration. I think that is, by any account, public or from the White House itself, marked by a deviation from the process that I just described, right down to whether or not career civil litigation experts at the Justice Department were consulted as to whether or not this ban would, encounter a certain level of litigation risk. So we know from reporting that process was not marked by the characteristics that I said. Go, now to travel ban 3.0, and you see, just based on the description, and frankly, as the Supreme Court has now taken some action in the last 24, 48 hours, an indication that they think some of that process was kind of returned to the travel ban process. The other thing I would say is, so is that a hallmark of how the National Security Council and its staff are now working in a more, quote, traditional way? Perhaps. Going against that, I would say, to take up your North Korea hypo here, we saw very disparate statements coming out of, whether it's the president and the White House, to Secretary Mattis, to Secretary Tillerson. At different points, we've seen kind of a disparate set of statements, which does not mark the kind of coordinated approach that I mentioned.
I would only add two things. One is having Lisa and I have both been in an administration in its early days, and it's a chaotic experience, I think, in any administration. And clearly, the early experience with the travel ban was not in any way a sort of ideal or even close to acceptable process, but so I think, and some of there were early indications about how they were making decisions about strikes, et cetera, that suggested maybe not the process wasn't down yet. But there do seem to be running through the NSC the regular process of meetings. So on core issues like North Korea and others. So, you still have to, that's not all you need, but it does appear that they have an NSC process running.
Okay, and let me ask you a specifically legal question about North Korea, which is, do you believe, given the missile launches that have taken place, given what we apparently know about their possession of nuclear weapons, given the rhetoric, that the president has the power to use military force against North Korea without any advanced congressional authorization? As a sort of related question, by the way, I've always wanted to ask, what is the source of legal authority under which the president keeps the military presence that we have on the Korean Peninsula? Does it go back to Truman and whatever the initial authorization for the use of force was in the first place, and it's a continuation of that? So both of those legal questions, if you'd be willing to...
Not having served in the Truman administration.
Even I have not served in the Truman administration. I guess to take your second question first, I think we are in an armistice with North Korea, so there was never a peace treaty. It's just a sort of continuing the armistice. But I think that the locating the fact that the troops are there, authority would be Title 10. I mean, I don't know, I can't sort of get too specific, but I think we have authority to station troops in a number of places. I don't think there's some different authority for North Korea. But it could, the fact that we technically are still at war, but in armistice, I don't know if that has a legal impact. I think it doesn't. On the first question, does the president have the authority currently, given the current facts, to use force in?
Yes, as you understand the relationship between Congress and the president with respect to the use of force issues, and given what we know about the situation with North Korea, do you think the president would be justified in initiating the use of military force? Would it depend on the kind of military force that the president used? Do you think instead he would have to get congressional authorization in advance if it's not a response to an immediate and imminent attack? What does imminent mean, obviously, in the context of a state that has nuclear weapons and possibly interballistic missiles that can reach the United States, et cetera? I mean,
so this is one of the eternal questions, but my view would be no, under current circumstances, without something more, that the president would not have the authority. There is the "what are you going to do to me" kind of aspect to all of these war powers questions. There's an enforcement issue, but it also would be extraordinarily unwise, I think, just politically, and it would make little sense at this point to use force without seeking congressional authorization unless there's some issue. I mean, there are operational, security secrecy issues, but that would be, pretty, I think, on the extreme to use force in the beginning of any kind of sustained way without authorization.
I think I'd say a few things. One, on your second question, in terms of our posture of our forces, I think obviously Mary's quite right. We have forces postured in a whole range of places. Quite obviously, they're also there with the consent of the South Korean government, right? So that is part of the authority for their being there. With regard to the force question, I mean, you said two things, Rick. One was, what's legal authority, and would it be justified? I actually think of those two things as two separate questions. Legal authority, I mean, it does, it is in the context of as against what, right? You said unless facing an imminent threat, which of course takes you down the question of what does imminence mean, and when you have a nuclear armed power in the form of Kim Jong-un and the North Korean regime, and if not the ability to threaten the United States right now, certainly the ability, some with the Seoul and its residents, some 30 miles, 35 miles south of the border of North Korea, certainly our ally faces, one could argue, an imminent threat. So I think you would have a whole range of questions as to what is imminent in that context, and of course a whole range of U.S. citizens, not to mention our troops, within that 35-mile range. So, is there a legal justification for the president to act in the face of an imminent threat? Yes, I believe there is. Is there, would that be justified based on, threats or rhetoric or fire and fury from Kim Jong-un? That's going to be a whole set of political questions that he would have to justify that, takes you down a whole nother set of of rabbit holes. I personally do not think that in their current construct, we ought to be having a debate or promoting an AUMF for North Korea in our current construct. I think one could argue that could be seen as provocative by Kim Jong-un. And, I think you want to proceed quite deliberately and quite carefully in this space.
So I think that's actually quite a fascinating point, that it's an argument against the view that authorizations for the use of military force in contexts like this are a good thing, and maybe it's relevant to whether they should thought to be legally required. That the very passage of the authorization is itself such a provocative act that changes the status quo.
Well, I guess
in a way that we ought to be certainly very careful about.
I think we should be, but also because part of the rationale for an AUMF is to demonstrate, at least in my view, a unity of view amongst the branches, the executive branch, the congressional branch, right, the legislative branch rather, and to show be the manifestation of some political unity as represented by those in Congress from the public, to have a deployment of troops in Iraq and Syria or whatever. I think given the state of at least political discussion right now as to whether or not, folks would feel comfortable having President Trump wage a preemptive war in North Korea, I don't think having a AUMF debate in Congress right now makes that much sense, given the unique kind of posture of somebody like Kim Jong-un.
And to be clear, I agree with that. I went by saying that he should get authority. I wasn't meaning he should run over there and get it right now. And obviously, I only know what I read in the papers about the facts on the ground. But it has not only the kind of external potential impact that Lisa mentioned of being sending a signal internationally, sending a signal to North Korea. But there's a kind of a subtle, I don't know, there is also a subtle, tendency to move to the edges of authority. And so it actually can have, I think, authorization that is given before it's needed, can have the impact of kind of pushing internal deliberations as well in the direction of using force.
So let me shift gears a little bit from North Korea, which we could talk about at considerable length, but to open up the larger issues about authorizations for use of military force that we've been talking about, and this is one of the ongoing issues ever since 9/11. We have been operating since 9/11 under these two authorizations for the use of military force. Both the Obama administration and now the Trump administration has felt comfortable relying on those authorizations to say there's legal authority for, an expanding geographic scope for the use of military force. There were some criticisms this morning, I'm not sure if you heard them, about the use of the AUMF to ISIS. We've seen,
I'm sure I can kind of
Yes.
conjure up what the criticisms would have been.
So, and this is something, we've been debating this, policymakers, academics, for many, many years at this point. The Obama administration tried to push Congress a bit to adopt a new authorization. Last spring, there seemed to be a moment where there might be some consideration in Congress about a new authorization for the use of military force that would try to tie it to more of the contemporary circumstances that Senators Kaine and Senator Flake jointly introduced. I mean, none of this has gone anywhere. None of this has actually even led to very sustained, extensive discussions in Congress. The operations go on. What's your view about a couple of things here? One is, why is it that we don't get any updated authorizations? There's a standard story you can tell about, Congress wanting to avoid responsibility. What can presidents do, if anything, to push Congress to actually act in this area? And secondly, does it really matter as much as a lot of us tend to think that these authorizations haven't been updated? Yes, it would be nice if Congress were on record showing support, but yes, it would be nice for formal purposes of ensuring that presidents understand that they're operating on the basis of congressional delegation. But this has been the status quo for so long now. How do we understand that status quo? Why is that the status quo? And as I say, does it really make a huge difference that we haven't updated these authorizations?
Well, I think that, look, I was one in favor of seeking a separate authorization for the ISIS operations because I thought it was important to have both branches acting in concert when you have our men and women in harm's way. I think that makes good sense. And it is something that it is both good government and good practice and has a way of showing unity not only from the public, but also to our adversaries, that we are unified in our approach. I also will tell you, though, that the concern I and others had was that that was one question, but opening up a kind of Pandora's box on the 2001 AUMF to rejigger that in the politics and the situation as it was and continues to be in Congress, that was very dangerous in my view, because I think we still very much need that continued authority, as has been painfully apparent in the expansion of al-Qaeda in Syria, et cetera, and I could go on in terms of the continued threat that al-Qaeda and its affiliates pose in areas around the world. And so I think we do continue to need that authority. And so I was very concerned that even as it was important to go to Congress for an ISIS AUMF, that we not, in so doing, open up a debate that then ends up, frankly, to use a technical term, messing with the 2001 AUMF that I think we still need to combat al-Qaeda in its current manifestation, which includes the largest affiliate it has ever had now operating in Syria. So, to your question about why is it that we weren't successful, I mean, I think it's pretty patently obvious that the political will to take a hard vote on any type of use of force issue, people learned their lesson with the Iraq vote, and that has been hung around members' necks for, since that vote was taken, unfortunately.
Yeah, so, I think on two points. One on, it doesn't matter whether we're operating, particularly with ISIS, on 2001 Al-Qaeda or 9/11 AUMF, it matters. I mean, using force is obviously one of the most serious things a president can do. And you want it to have it on a serious legal foundation. And to the extent that the foundation that it's on is being criticized fairly broadly, and is not, it's not as, it doesn't have specifically, Congress speaking to it, that's not good. And I think it does, does it matter legally? I don't think that makes the actions taken under it illegal, but it is certainly something that is not the way I would want to see our government operating when we're using force. And that was obviously the view of President Obama as well, and his advisors. But what can a president do about it? It's, if Congress doesn't want to take action, which they clearly, some members do and did, but as a body, there's a lot of, just avoidance of these kind of major force issues. If they don't want to, the one thing that the president could do is say, I am not going to take this action that is necessary for national security unless you do. So I'm going to sit here and I'm not going to do, not going to use force in a situation that I deem to be critical to national security unless you do something about it. And that puts the pressure back on them. But not many presidents are going to do that, and I would argue they shouldn't. That's a position that a president
Let me ask you a
shouldn't
question
do.
I've always been curious about, which is there is this story which has a lot of reality to it about congressional desire to avoid responsibility in this space, especially since the Iraq War vote. But how much do you think the Supreme Court decision holding that the legislative veto is unconstitutional plays into the inability of Congress to step up and actually address changing circumstances with these AUMFs? And what I mean by that is these are genuinely hard problems to legislate about, given the nature of the threat today. So you have issues about how you define the geographic scope, if you do define the geographic scope of a use of force provision. You have the issues of how you define the groups against which the force can be used in a world in which these groups are changing and adapting and splintering and the like. You have the questions about whether there should be a temporal scope to the authorization of the use of force or not. There's sort of the general tension between how general a level of authorization you adopt and how particular and specific an authorization is. And those are all genuinely perplexing questions, I think, in this area. If Congress could authorize force but then claw it back more easily in response to specific applications through a legislative veto type process, I wonder how much more willing Congress might be to take the first step of authorizing force, in part because there are obviously people who are worried, as Mary said, about once you authorize the use of force in some broad way, it will get expanded and expanded and expanded, and there's no way for Congress realistically, which has to overcome a presidential veto, to claw any of that authority back. So I've wondered how much the shadow of the elimination by the court of the legislative veto casts over this whole problem.
I think my reaction to that is, for it to have an impact, the court's writings on the legislative veto, et cetera, Congress would have to have read any of that or be kind of, I mean, just kind of very kind of practically speaking, I don't think that that's what goes into those debates. I think you're absolutely right that the question of geographic scope, issues of the temporal nature, et cetera, question of how do you describe what is a significant number of troops and the like, those are all considerations from a political standpoint, a policy standpoint, that the executive branch doesn't want their hands tied, and the Defense Department doesn't want their hands tied, and the president doesn't want to sign up to something that precludes him or her from, dispatching a special ops team for a hostage rescue scenario. I mean, those are very practical and at bottom political considerations in terms of what are you going to say you're signing up to, that I think those are legitimately hard questions that both bodies and certainly the operators in the executive branch want to make sure are answered in a way that does not tie their hands. That is, I think, what goes into the difficulty here, and then the members of Congress having to kind of raise their hand and defend whether or not they signed up to that constraint.
Yeah, I mean, I don't know enough about the legislative veto and its use before it was taken away and whether it was used under these circumstances. But I mean, I would just echo what Lisa said, and I don't think that the at least currently what we're seeing, the reluctance on the part of Congress isn't, I don't want to authorize something that's too broad and then, who knows how they'll use it, as much as I don't want to be on the line for this issue one way or another. And I don't think that the availability of a legislative veto would impact that.
Okay, let me shift to another topic that I think is one that's a more recent set of national security policy concerns. It's been around for a while, but it's obviously gotten so much more attention in recent years, and we are only beginning to have these discussions, and that is the whole cybersecurity area. And with respect to the issue of the conference on executive powers versus congressional powers, what's your view right now about whether the president has enough power to deal with these issues, however they should be dealt with, given the existing congressional legislation in this space, whether Congress needs to legislate in this area for a variety of reasons, and if you can tell us some of the specific reasons that are involved. Of course, we have all these uncertainties about how the laws of war and the authorizations for military force apply to cyber attacks. Anyway, I want to open that subject up, but particularly from the perspective of the role of the president, the role of Congress, and whether the Congress needs to legislate in this area to give the president the requisite authorities.
So my reaction to that is when it comes to quote-unquote cyber operations, I don't know that there's a lot that Congress should be doing in terms of providing authorities to the president. I think there's, and this gets us back to the discussion we were just having vis-a-vis North Korea and the like, I think that there's authority for the president, and there's separate questions about capabilities within a U.S. Cyber Command, et cetera, and the intelligence community. But you get very quickly into the set of questions about what is a use of force in cyberspace. There is not agreement amongst like-minded nations, even to let alone a broader segment of the international community, absent, say, a cyber operation that has a kinetic effect resulting in, lives lost on critical infrastructure in peacetime, right? So maybe you'd get a set of folks in agreement that constitutes an act of war, but barring that, there's a whole lot of gray space that is quite murky in terms of what constitutes a use of force in cyberspace. So then that gets you into your question about, then what should be notified to Congress, what should be the impact of the War Powers Act, et cetera, et cetera. So in terms of authority for the president and capabilities, I think you've got those, but in terms of set of norms of behavior or international law recognition of what is a use of force in cyberspace, I think it is very much the Wild West.
If a foreign government hacked into our voting systems and actually changed votes in a presidential election, would you consider that an act of war?
Unsurprisingly, not the first time I've gotten this question. Yeah. I mean,
So
look,
you must be well prepared to answer it.
No, look. I mean, look. This is here's the one of the questions. I kind of turn it right back around, which is to say, prior to January of this year, our voting infrastructure was not deemed critical infrastructure by our own government, right? So to the extent that there was a space where we might have kind of normative or international law recognition about an attack on critical infrastructure, we didn't have agreement on that. So that's just an illustration of where some of the murkiness is. But you wanted to say something before about the...
Well, yeah, so on that, I think probably not, on your second question, not an act of war in the sense of a use of force or an armed attack that would justify, we're talking international law here, force in response, but certainly an unlawful act under international law that you could use countermeasures. There are things you can do. And the problem with so much of cyber when you're talking about the operational side of it is it's usually almost everything is below the use of force level. I mean, there's very little that rises above. So it's as Lisa said, the constraints I think on the president in the cyber area are almost really largely, almost completely practical constraints. It's very new, so the law isn't developed. Happily, there haven't been that many, certainly in the force area, that many circumstances to kind of develop the law. So it's lawyers are working away diligently, but the law develops slowly, and so there's that. And I think in the case of, I think the president has a lot of tools, and Lisa would know this better than anyone, but a lot of potential tools to deal with these things. There's sanctions, and there's military options, and there are covert options, and there are diplomatic options, and there's law enforcement. There's a lot of things to do. The problem is they don't work that well in this context, and so I think that the problems with cyber on that side, are largely really policy constraints and effectiveness constraints. On the legislative question, I would say to the degree, I don't see a lot of room, but to the degree that another constraint in the cyber area, on the cybersecurity area, is that so much of what we need to protect is in the hands of the private sector. But I don't think, and so there were efforts at regulation which failed just completely, and I think nobody is thinking about bringing that up again. But there are probably some things that could be done to legislatively to kind of up the game in the private sector, but that might be the only.
I mean, on what Congress can and should do. And to take your election, not hypo. We are spending a lot of time, and I think there's important bipartisan efforts about investigations from the congressional standpoint into what happened in the 2016 election. But we need to be focusing, in my view, considerably more than we are, about readying ourselves for Russia and others to come back. They are coming back. There is absolutely no doubt in any expert's mind who you talk to about this that is the case, having concluded that they were largely successful in terms of sowing discord and division and confusion in our process. So they're coming back. What should we be doing about it? Well, we have the state and local election systems that are entirely owned, operated, managed by state officials down to the municipal and county level. There's some 3,000 counties across our country, some of which have 5 to 6 different types of voting systems. So what should we be doing as a government to enable them to shore up their systems? We ought to be legislating around this issue. Substantial resources need to be added to the states. There needs to be bipartisan consensus on the part of the states that they should take assistance from the federal government and not see it as a big brother federal overreach and takeover of the election system, which is the response that we got when we tried in the summer of 2016 to assist state and local secretaries of state to shore up their systems. There needs to be bipartisan approach from the federal government to shore up those systems in the form of basic best practices around encrypting voter databases. So there's a whole set of things that Congress should be productively doing in this space. The second thing I would say on your use of force question is we do not yet have the kind of muscle memory around the legal and operational process to respond to cyber threats that we have formed in the last decade and a half to respond to terrorism threats. So to give you a very concrete example, you have a cyber threat emanating from a third country, and there is a potential cyber operation to take place to address that. Well, what are the questions of sovereignty in using the equivalent of a cyber bomb to address that threat? If that cyber bomb has to travel through a third country to land, I'm stretching the metaphor here. Well, we don't have the equivalent of requesting overflight of that third country to deliver that cyber bomb. These are all questions of international cooperation, communication, norms of behavior that we're just, I think, really beginning to grapple with.
And is there a successful process that's in place for grappling with this? I mean, this is part of the problem is that I can imagine bilateral agreements being easier to work out, but international law has no real mechanism for adapting itself to these changing circumstances.
Well, yes and no.
Except
right?
if you make treaties or conventions or things like that, but
or state practice and
state practice, which means, but that's circular because what should the state practice be in the absence of?
There was an effort that unfortunately recently broke down in the UN, the group of governmental experts that had gained some traction around a set of norms. In the Obama administration in the second term, President Obama was extremely focused on raising cyber norms issues in any multilateral fora we could. Because there was, you've got the G20 that is focused on economic issues and competitiveness and the like. So he said, we're going to take this up there. And in fact, we got G20 agreement on a set of cyber norms. But all of that requires a whole lot of leadership at the head of state level and a willingness to push that and the legitimacy of that leader to be able to bring other nations along.
And, so I would just say, I do actually think there has a progress has been made. A lot of progress was made in the later years of the Obama administration, but it's long, slow. The development of international law, particularly in the absence of, major events, and we've had a lot of events, but, a major kind of force event, it takes a while.
There's some interesting work being done, though. So Brad Smith from Microsoft has this very interesting concept of having a, Geneva Convention for cyberspace to protect, civilian populations outside of times of war. So, those types of things are getting traction in some of these discussions, but I think Mary's quite right. It's a long, slow process, but very importantly, it takes head of state leadership.
I think we're at the period where we're taking questions from the audience. So if people do have questions, I guess someone will distribute the cards. And while we're waiting for the questions, let me just respond to that discussion by just asking, isn't the United States going to have to act alone for a period of time in this area, given how slow-moving it's going to be? A Geneva Convention for dealing with these issues would be 10 or 15 years in the making, probably.
One could argue that we have,
Yeah.
and we will continue to. So yes, I think is the answer to that.
Yeah, I think, I agree. I mean, alone and then also, but working and explaining our positions internationally, trying to get, bring people along. But sure, absolutely, we would
And
act
we
alone.
should be setting, we should be acting, and we should be trying to set norms by doing the following thing, which is naming and shaming and calling out hostile state actors who engage in malicious cyber activity, and then, very importantly, imposing costs. Imposing costs on those hostile actors, as we did in China in the indictment of the 5 PLA members who were perpetrating huge thefts of intellectual property from cyber-enabled economic espionage from our companies, as we did in imposing sanctions on North Korea, in imposing sanctions on and indicting Iranian actors for the hacks into critical infrastructure here and our financial services companies. So time and again, and of course, as we did in imposing sanctions and calling out the Russian-sponsored activity in our election. So we have got to continue to impose costs.
We have 5 minutes for questions, so I guess oh. Okay, now I can read the handwriting. I was having, it's not that the question is inappropriate. So this is a question about surveillance and the reauthorization of 702. And if you want to speak a little bit to your views about where we are currently in surveillance policy, whether there's a need to reconsider some of these issues legislatively, but the general anxiety about surveillance.
Well, so I guess one thing I would say, and we're talking about executive authority and constraints on executive authority, and sort of does law in the national security area constrain the president? And I think in one place there's a range of answers to that question, but one place it certainly does is in the domestic surveillance area. Meaning, the significance of what is passed is very important. I don't know. It doesn't. I mean, from what I understand, recent efforts on the Hill, or I think I read something that they're going to put just a straight reauthorization on some must-pass bill. So I don't know the ups and downs of what's happening with 702 right now. I have a feeling. I know they have to extend it, or it expires. But I don't anticipate a lot of new thinking. A lot of new, anything new in the coming legislation. There are efforts to close up the backdoor search loophole, but I don't anticipate that much is going to happen there.
We may have something coming through constitutional doctrine for domestic.
Well, yeah, that's right.
Purposes.
And that could be quite significant. The Carpenter case could be quite significant in certainly law enforcement, but also to some degree in the surveillance area.
I think we have time for another question or two. There are questions about the Obama justification for the use of force in Libya, but I think I'll defer that to the panel that Bob Bauer is on, since it's publicly known that Bob is the one you are to go to for all answers on that question. Can you discuss your path to a legal career in national security? And who do you feel your client is in national security contexts? Those are interesting questions from this audience. So.
I'll take a quick stab at that because I literally have got to run out the door in like 1 minute so that Dean Morrison is not upset with me for missing my very final class up at NYU Law School. So, sheer luck in terms of having great mentors and great opportunities to have a range of national security law jobs. In terms of the client question, I think it's a fascinating question, and one of the things I cover in the seminar that I'm teaching this semester is the different roles of the lawyer in the in the national security process, and I'm looking at one of the best lawyers we had fulfilling a whole bunch of roles, Chris Fonzone, who's in the audience, and who recently came and talked to my seminar about this. And I had great fun working when I was Assistant Attorney General for National Security to help lead a set of operational lawyers, as I dubbed them, trying to help and represent the intelligence community before the FISA court and work with FBI agents on terrorism cases and the like. But then you have the whole other spectrum of those in OLC who are the best view of the law lawyers, and I'm sure we can have a whole debate about that. And of course, folks like Mary and Chris who really shepherded the the legal options that could be presented to the president to support the policy recommendations that the NSC would make. And I just say to those law students or budding legal types in the audience, there's so much interesting work to be done, and you've got a great set of people here that you should be talking to about it.
Mary, do you want to just say a word about how you got to where you are, and then we'll close the session because Lisa has to run.
I mean, I wouldn't say there's a path to follow. It's kind of luck. And when you talk to people who are in our world, that's a story I think you hear really regularly. Is that I just happened into what looked like an interesting job at the Department of Defense, and then I met someone, and I went into another job at the Department of Defense, and then NSC, and then I was hooked, and I, sort of continued in this, in the national security area through think tanks and the Hill, and then back to the White House. So I can't, it's a lot of luck and just sort of what hits you, but I started at a law firm and hard work, yeah.
Well, we unfortunately have to close the session off now. I want to really show my appreciation to Mary and to Lisa. Fantastic discussion. And we promised Lisa we would let her get her plane to teach her next class for NYU today. So we'll adjourn.